Alrighty, welcome back to another episode of Law Scholars. In this episode, we are going to be comparing the right to counsel as outlined in Miranda, and then the right to counsel as outlined in the Sixth Amendment. If you remember from our previous episode where we actually introduced Miranda rights, we talked about two cases. And those two cases were Messiah and Escobedo. In those cases, the officers ended up gathering some evidence in an improper way against the right to counsel, and the court said that this was a violation of the Sixth Amendment right to counsels. That meant that Miranda was kind of teed up to being a Sixth Amendment right to counsel, but instead the court ended up saying that this is a Fifth Amendment right to counsel as far as when it comes to reading people their Miranda rights. Because this is where things get really interesting. The Fifth Amendment does not expressly protect the right to counsel, but Miranda requires an express warning of the right to counsel to be provided to the excused individual. This warning is going to be distinct from the right to counsel protected in the Sixth Amendment, and the timing between Miranda and the Sixth Amendment is also going to be slightly different. For Miranda warning, the right needs to be disclosed to the accused before any custodial interrogation takes place. But for a Sixth Amendment warning, a Sixth Amendment right to counsel, that needs to be disclosed at the time of charging, or really when the prosecution begins against that person. The main question is going to be whether the Miranda warning is also sufficient to inform the accused of the right to counsel underneath the Sixth Amendment. So we have our Messiah and we have Escobedo, but then we have a couple of cases here that really illustrate how this is going to work. We have Brewer versus Williams. This is a case here where we have actually discussed this previously when it came to inevitable discovery. Now we're going to be revisiting this case. Maybe you'll recognize it, but what happened in Brewer versus Williams? It's two lawsuits. This was the first one. Williams had abducted a young girl in Des Moines, Iowa, and then disposed of the body on his way to Davenport, Iowa. Williams was arrested, and he was arraigned in Davenport, where he had talked to multiple attorneys, and the attorneys told Williams not to talk to the police. Williams did turn himself into the police, and as the police were escorting Williams back to Des Moines, they were looking for the body, and the officer knew that Williams was a deeply religious person, had some mental health issues, and for this reason, he was very careful in the speech that he gave, but he ended up giving what's called the Christian burial speech. Knew that Williams was Christian, and in the speech he was just saying it would be a pity for us not to find this girl and to give this girl to her parents so that she can have a proper Christian burial, because of the impending weather and the inability of potentially not finding this girl. After the speech had been given, Williams ended up directing the officer where the body could be found. So, now the question is whether the police deliberately elicited a statement from Williams. It's very clear here in this case and that the police did deliberately elicit a statement in violation of the Sixth Amendment. He had been arraigned. Counsel was denied the opportunity to ride with Williams back to Des Moines. And so any statements made by the police that was designed to elicit a statement from the defendant was going to be in violation of the Sixth Amendment right to counsel. So, his statements are clearly going to be out of evidence. Williams directing the officer to where to find the body, it's going to be out of evidence. But what about the body? Can the actual discovery of the body come into the evidence? And this is where we get into Nix versus Williams, part 2, where the body can come into evidence, and it's because of inevitable discovery, because the search party was in the area around the same time, and that Williams ended up directing the officer to where the body was located. Okay, we have one more case. And this is Rubalcado versus State. What's the rule here? Well, after the Sixth Amendment right to counsel has attached, if the police knowingly circumvent that right by using an undisclosed government agent to gather incriminating information, well, then those statements may not be used as evidence at trial. So when does the Sixth Amendment right attach? Well, attachment occurs automatically once the individual is subject to prosecution. What is prosecution? This is going to be a formal charge, arraignment before the court, or an indictment against the individual. Attachment is going to be crime specific, using double jeopardy standards to determine whether or not the Sixth Amendment attaches to each individual crime. Knowing circumvention is going to occur when at least one state actor knows of the attached right. If any state actor knows about this, well then all the state actors have imputed knowledge of that right. So even if they don't know it themselves, that knowledge is assumed imputed against them, and those rights are going to attach against all other government agents. And then finally, eliciting information occurs when the agent makes an initial express attempt to gather information. Simply being a listening ear is not going to be enough to elicit information. And finally, a defendant may waive their Sixth Amendment rights by initiating the conversation with the informant. So what happened in this case? I'm not entirely sure of the details, but let me give you a hypothetical of how these rules are going to apply. A person has been charged with a crime, and they're booked in the jailhouse. The officers put in an informant in the same jail cell as this person who's been charged with the crime. If the informant goes in there and asks, "What did you do to get in here?" and the person discloses that, well, that's going to be a violation of the Sixth Amendment right to counsel. But if the informant goes in there and simply listens and says, "I got in here," if the informant says, "I got in here for doing such and such," and then doesn't say anything else, and the defendant then confesses what they got in there for, well, then they are simply being a listening ear, and they did not elicit any information, and any evidence gathered by that informant could be included in that kind of situation. So that's when those are our Sixth Amendment right to counsel. When does it attach via the Sixth Amendment versus how is that different from Miranda, and how those things kind of work hand in hand. Different, but related. All right, that's everything for this episode. Have a good one, and see you later. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.